Welcome to the DCSBDC COVID-19 Initiative webinar series. We do these every Monday at 12 noon, and we thank you for spending your lunchtime with us. Today, I'm going to introduce myself. I'm Danielle Ricks. I'm one of the facilitators for the DCSB business. I'm a counselor there with some of my other cohorts. We are all content experts and subject matter experts. And today we're going to be talking about using COVID-19 and working through that with some legal help from our fabulous presenter who's coming up next. The agenda for today, we'll do an introduction of our wonderful presenter. We'll talk about legal disclaimers. She is a lawyer, so she has a disclaimer for you before we continue. The goals of the presentation. Topic of discussion today is e-commerce basics, intellectual property rights, and under that is trademarks and copyrights. So for those of you who have started your business, but maybe you haven't gotten all of the legal paperwork done, or maybe you have to pivot your business because of COVID-19, and you need to understand what those basics might be as you pivot, particularly if you're moving online and you need an e-commerce refresher course, she's gonna go over that for you, and anything that you need that's going to be a deeper dive, we request that you go on to DCSBDC.org, and you'll see that right down here at the bottom, and you can request a free consultation with our next presenter. And if I could advance the slide, that would be really good. Here we go. All right. So today we're going to meet Salma Benkabbou. Salma, did I pronounce your name correctly?
That's exactly right.
All right. She is known as the millennial business lawyer, and she's founder of the Benkabbou law firm. We are so incredibly grateful and lucky to have her with us as we walk you through her presentation. And because she is a lawyer, we've got a disclaimer for you.
Thank you, Danielle. I'm so happy to be here and excited to share this information and educate the attendees today. So as she did state, we do have a legal disclaimer. So this webinar does not create an attorney-client relationship between you and I, or between you and my law firm. The information provided here today is just for educational purposes, and so you will still need to hire an attorney to help you with your specific needs. Also, I do ask that if you do have any questions that you save them until the very end. And I also ask that any questions that you do ask, that you ask them in a general perspective. You don't want to ask any specific questions. You know, as Danielle instructed earlier, if you do have any specific questions to your business, you are free to sign up on the DCSBDC websites for a free consultation with me.
All right. Moving on. Might help if I go in the right direction. There we go.
All right, so the goal of this presentation is really not designed to be a DIY project. Obviously, it's you know, legal work. I know that a lot of times people think, you know, I read some articles online and I'm able to do it myself. You know, you're really shooting yourself in the foot. I always have this rule of thumb, you know, any service that requires a license to do is typically exempt from DIY anything. So you definitely want to hire the professional to handle those things for you. Reason being is because as you grow in your business and you become profitable, you become very much attractive to a lot of plaintiffs to sue you because you actually have deep pockets for them to collect on, right? And as successful as you get, you know, litigation is really inevitable and really oftentimes comes with success. So that's typically when people joke and say, I've made it, right? So today we're going to discuss the following topics. Danielle, if you don't mind. No.
Yep.
Thank you.
You're welcome.
So I'm going to just cover just the basics for starting an online retail business or an e-commerce business. You know, it's somewhat of a starting point for you to have considerations, not only from a business perspective, but also from a legal perspective. It's a lot deeper than what I'm sharing with you today, but in the interest of time, I just kind of focus on what business owners need to know. I'll also cover intellectual property generally. So there are 4 types, but I wanted to focus today on trademarks and copyrights in the interest of time, because that's typically the topics that people have a lot of questions on. All right, so let's start out with e-commerce. So there's a lot of considerations that you need to consider in the beginning or the onset of your startup e-commerce business. I listed 5 factors here, and I'll go through them one by one. So the first thing that you want to do is identify who the retailer is going to be. As an e-commerce business, you're essentially considered a retail business, right? So instead of having a brick and mortar, you have an online storefront, and you want to identify who the proper owner or owners are going to be. So you want to think about, is this going to be owned by you personally? Are you going to own it by, a business entity? And which business entity is right for you, and making sure that you have that conversation with your business attorney and setting up your company. A lot of times people will have existing businesses and they'll think they can just set up DBAs, to start an unrelated business. Is very dangerous to do. Specifically, you don't want to commingle all of your profits of all of your different businesses. The biggest risk, I would say, is essentially subjecting all of your profits for lawsuits, that you have with one business. Now all of your profits are within one pool. So, you want to just be mindful of that liability and separating assets as you see fit. The second thing you want to consider is you want to make sure that you have purchased or secured the products that you plan to sell. You obviously don't want to start selling without having the inventory in place, or if you are doing drop shipping, that you have all those mechanisms in place as well so that you're able to meet the demand of your customers. If you're selling digital products, you want to make sure that you identify how you will provide those products to your customers, and making sure that you clearly identify that and flesh that out before you launch your business. The next thing you want to consider is, what territory is your business going to be serving, or where are you essentially shipping all of these products or providing these digital products to? Is it just going to be in the United States, domestic, or is it going to be international? And there's considerations for both depending on, which territory your business will serve. The fourth thing you want to think about is, setting up your website, right? So you want to make sure that you design and develop the website that will host essentially your products for sale, and making sure that it's adequate enough to function as an e-commerce site. And then lastly, you want to think about, and most importantly, I should say, the legal materials that are required for your website so that you can ensure that you're limiting the legal liability as much as possible. E-commerce businesses do have legal risk, and you definitely want to make sure that you have these things in place before you launch. So I'll talk about the legal materials on the next slide.
All right.
All right, so the first thing you want to think about is essentially your website's term of use, right? This is essentially a contract between the user and the website owner that specifies, the use of the website. And it is supposed to function as a means for you to limit the liability that you can have from any posts from your users. You can prevent them from infringing on your intellectual property, so prevent them from stealing your blogs or your copy of the website, or any type of information that you have on there that you don't want them to utilize without your consent. Also, if you do have, the ability to allow for users to leave reviews and comments, you want to make sure that you have policies in place under your terms of use that specify, that you are allowed to remove any defamatory information or any third-party information that can also be considered an infringement on other people's intellectual property rights, right? So that's really important, piece of legal aspect that you want to have on your website, and you want users to be able to read it and agree to it. The next thing, and this is really, really important that people have in place, are privacy policies. This policy essentially just puts the user on notice of all of the activity that you're collecting or their personal information that you're collecting and what exactly you're going to do with it. So, we also have a variety of different privacy policies that are at stake. We do have the international policy, or the European policy of GDPR. That was enacted or came into effect in 2018. So that's now applicable to any business that essentially has users from Europe. Doesn't matter where they reside. It just, they have to be an EU citizen and they have to have access to your site. Obviously, because our sites are, held on the World Wide Web, we can't just assume that because we're a US-based business that we don't have international site visitors, specifically those from the European Union. So you want to make sure that your privacy policy is compliant under GDPR regulations. In addition to that, earlier this year, or as of January of 2020, California has its own privacy policies that are different than the federal privacy policies that are at stake. Essentially, the state of California has heightened their privacy rules and regulations. And essentially, if you have any California resident as a visitor to your site, you want to make sure that your privacy policy is compliant with their regulations as well. Now, the next thing is sometimes included in your privacy policy, but sometimes it does need to be separate. And that's the website online behavioral advertising policy. And basically this is implicated if you are following the user and outside of your site and where they're going. So typically this is implicated on Facebook ads if you're using any of those mechanisms in order for you to market and advertise your products. Essentially, Facebook ads track the user and where they're going and where they're shopping, and that's why you're able to use a lot of their behaviors in which you can identify and target them. So you want to make sure that if you are using any of those online behavioral advertising methods, that you're able to essentially have them agree and disclose that you are doing that, right? So you want to make sure that you have that on your site. And sometimes you might just track where people are going from page to page on your site. So that's something that you also want to be mindful of, and making sure that this particular policy is on each of those pages that you're tracking. The next legal piece that you want to have in place is, your retail terms of sale. This is essentially, think of it, your sales contract. And this is where, a lot of disputes can come up more frequently. Reason being is because this deals with refunds, this deals with exchange policies, shipping and handling type of policies. And so you want to make sure that you're clear and transparent about all of your, business dealings. And, you're being transparent about what your expectations of your business are to that consumer, and vice versa, and what are the things that you're expecting from them. So this is not, obviously one size fit all. Each business is different. They all have their different business practices, but you definitely want to make sure that you capture your own specific business practices within the retail terms of sale. Now, you also want to make sure that this is somewhere where the consumer is going to check out, and that they agree to it at checkout. You don't want to just kind of hide it in your website where they can't even see it, so they don't know what they're agreeing to. Right. And then lastly is the copyright policy, or the Digital Millennium Copyright Act, DMCA for short. This essentially provides you, the business owner, a safe harbor under the DMCA to protect your online business from any copyright infringement liability that results from certain acts of your users. And this kind of goes back to the website terms of use. You want to make sure that you're limiting what can be posted on your site, and then also making sure that you have a policy that allows you to, avail yourself of that copyright infringement protection in the event that you don't catch it in time. All right, so in addition to the legal matters in relation to starting and setting up your e-commerce site, the next slide, Danielle. Thank you. The other thing you want to think about is the legal aspects of your e-commerce marketing. A lot of times people don't really pay too much attention to this, and this is where a lot of people can get in trouble. And because in the interest of time, I couldn't go, dive deeper into each one of these topics, and they're not all applicable to everyone because everyone uses different marketing efforts. But specifically, just understand that there is, regulatory laws that specifically regulate product labeling. If you're selling a product, you want to make sure that, you're complying with the FTC and FDA regulations, depending on what it is you're selling. Affiliate marketing, if you're using social media affiliate marketing, making sure that you have contracts in place and you're abiding by the rules and being transparent in terms of the FTC guidelines. Sweepstakes marketing, and this is essentially where you're offering either a free product for certain things that people have to do, follow you or leave a comment, etc. There's regulations to that you want to make sure you're complying with. Obviously, social media marketing and making sure that you're not, you know, stealing other people's content and using it as your own, etc. And then if you're collecting email addresses, you know, the FTC is very clear on how, you know, they want you to be able to do that. I know a lot of times people will just meet others and they'll take their email address and automatically add them to their newsletter marketing. You cannot do that. You have to ask permission before you do that. So I'll just give you guys that little tidbit, in addition to other factors you need to think about, but primarily I know a lot of business owners are guilty of doing that. So I just want to make sure I mention that. All right, so that about does it for e-commerce. The next topic I want to talk about is intellectual property. So a lot of times people may not understand what intellectual property is, and a lot of times they misclassify it, misidentify it, which is understandably so. It's a very complex area of the law, requires a lot of specialized knowledge and expertise. So this is definitely something that you want to seek legal counsel for. But essentially, you know, intellectual property is a work or invention that's just a result of your creativity that you have rights to, and you can protect it by either applying for a patent, copyright, trademark, or you can keep in-house as a trade secret. So in the next slide, I define for you the rights that are protected by each, just to kind of give you background. So trademarks are, you know, they protect the use of symbols, words, sounds, you know, anything that identifies your brand and commerce. Think of it as, you know, what does a person or a reasonable consumer see or hear or view, and sometimes even smell, that reminds them of your business. For example, when I say, you know, you're in good hands, you're probably thinking Allstate. I don't have to tell you that it's an Allstate slogan. You probably just recognize that from all of the commercials that they have. Or the Nike, you know, just do it. I can just say, just do it, or a shirt can say, just do it, and you automatically know that's a Nike slogan, and therefore that's what trademark would protect. Patents are going to protect the use, sale, or manufacturing of an invention. Patents are even more specialized in the sense that they require a patent attorney that sits for a separate patent bar in order for them to be able to assist you with patents. So I know that there's a lot of, you know, DIY file your patents, and this is where a lot of people run into some issues because patents have limited timelines in which you can actually protect it. So if you do it wrong and you publish your invention in commerce, you might lose your right to protect it overall. So I would definitely say seek a patent attorney's advice as soon as possible if you do have anything that could qualify for patent protection. The next intellectual property right is trade secrets. This is essentially protects the privacy of your documents, your data, your formula, or as I like to call it, your creative greatness or secret sauce of your business. And essentially you're just maintaining it as confidential information in-house, where you're not allowing anyone else to have access to it. Anyone that does have access to it is subject to an NDA or non-disclosure agreement, also known as a confidentiality agreement. And not everyone that doesn't use the information for their job has access to that information. And then lastly, we have copyrights, which essentially protect the use or performance of original works of, 6 kind of categories of literature, art, music, drama, and really any other form of expression. All right, so let's talk about copyrights. Next slide. Thank you. So before I dive into what you need to know as a business owner in relation to copyrights, I did just want to give you some examples of what could qualify as copyrighted work. So we have books or ebooks. So for example, if you are selling a digital product, that can also be, any workbook that you have, any how-tos, checklists, things of that sort. Graphic designs, such as your websites, any graphics that you use for social media. If you have, anything that could qualify as graphic designs, essentially, could qualify as copyright work. If you're a fashion designer, your sketches are now eligible for copyright protection. This was somewhat hot off the press. In 2017, the Supreme Court ruled in a case where it was about a cheerleader design where there was copyright infringement. And so ever since then, fashion has kind of taken a step forward in this aspect. We have choreography, recipes, movies, music, photographs, specifically if you, not necessarily just a photographer, as the service that you provide, but also if you're a business owner and you are using photographers to take photos for your social media marketing or your website marketing, these are things you want to be mindful of as copyright work and who has the right of ownership. I do want to mention personal trainers who sell meal plans or exercise plans and so forth. And then we also have software code that's also eligible for copyright protection. So what do you need to know as a business owner about copyrights? Well, copyright ownership attaches to the work the moment that it's created by the creator. So the reason why this is important to understand is when you have someone that's creating the work for you, you want to understand when does that copyright attach. So if it attaches the moment that it's created, you know, essentially the person who's creating it, the creator, is the owner of that copyright. Unless you have a work for hire agreement that has a specific language under copyright law that reserves that ownership with your company, right? Or with yourself if you are, you know, just operating your business under your name, which of course wouldn't be advisable, but if you are doing so, you know, it wouldn't necessarily be your copyrighted work. It would still be the copyright of that third party that's independently hired to create that work for you. So when I talked about photographers, you know, obviously photographs qualify for copyright protection. You want to make sure. Oops,
Sorry about that. Sorry.
that's okay. You want to make sure that you have that contract in place before any work is commenced, obviously because the copyright ownership attaches the moment that it's created. Now, if you're sitting there at your, you know, at home or at your desk and you're thinking, oh crap, I've made a lot of mistakes already, that's okay. You can still, you know, get the ownership rights to your copyright. You just have to go about it in a different way, presuming the other side agrees to giving you those rights, right? You are at a disadvantage, obviously, because they have the legal leverage, but there are solutions that you can avail yourselves of to be able to get ownership of the work you create. Another thing I do want to mention is that when you are hiring people that work in an industry, specifically marketing, and they're creating graphics for you, you want to make sure that you hold them accountable to any types of infringement, as well as making sure that they're creating original works of authorship for you. You don't want something that they use for all of their other clients, because obviously that would cause some infringement in commerce, right? Now, the next thing I want to mention is, you know, automatic ownership doesn't necessarily mean that you get automatic protection. So you essentially have 3 months from the date of publication or before an infringement occurs to be able to, you know, get all of the protection rights under copyright law that are available to you, which you get great ones if you do take the step to file within this time span. You get statutory damages, and that's just a fancy way of saying that the court presumes damages for you. You don't have to quantify what those damages are, which is great. In addition to that, you get your attorney's fees paid for if you win. And now that's a huge legal leverage to have, because a lot of times people are not going to pursue litigation that they know they're going to lose, especially if they know that they're going to have to pay your legal fees on top of their legal fees, right? So it's a very strong intellectual property right to have if you do things the right way. So you want to make sure that you're registering on properly and on time. So that's about all the things you might want to know, or majority of the things you want to know about copyrights. The next topic is trademarks. So as we talk about trademarks, of course, I'm going to provide you with some examples, because I think it's important to know how to identify your trademarks. Although I don't recommend that you do it yourself, you still want to hire an attorney to do that for you, because it does require a legal analysis. But essentially, we have names, we have symbols, we have slogans, colors, sounds, package or store design, and now even generic domain names, which is actually, as of 2 weeks ago, I believe, the Supreme Court ruled on that, which has definitely been a game changer. Thank you to Booking.com, which is the case that was brought in front of the Supreme Court. That got me excited, because you essentially get like the ability to register as a trademark your generic domain name, which generic names are not eligible for trademark protection. So that's a big deal. So I do want to mention in these examples, so we have the Mercedes logo. Without me saying it's a Mercedes, you automatically identify it as the Mercedes logo. So that's a logo just by itself. We have the Tiffany's blue, which is essentially the color of that's registered as a trademark for Tiffany's. I don't have to say that it's Tiffany's. I think every girl would probably look at that box and know that it's coming from Tiffany's. We have the Apple Store here, which they were able to register as a trademark, their design of their store. So as if you are aware, if you ever walk by an Apple store, you don't even have to look up. You just look on the inside, they all look the same. So essentially they wanted to protect that design and making sure that no one else confuses it with any other electronics brand. Then we have Nike, where we have Just Do It and the Nike check. I use this example to show you that the Nike check by itself would be one trademark application. Just Do It would be another trademark application by itself. And then Just Do It and Nike check used together would be a third application used, especially because they're used separately by Nike and they're used together. So anytime that you are using combinations of your trademarks, and if you're using them together, you have to protect the use of them combined as well. And then I have the maker's mark example here, because the trademark here is the red wax. So that kind of goes to the package of this particular bottle shape. And so therefore it qualifies for trademark protection. I guess the people that drink this, I think it's whiskey if I'm not mistaken, they can recognize the bottle even if they just look at the red wax, right? So think of it as trademarks identify the source of origin of a particular product, or service that's provided. They essentially tell you what company represents or owns that trademark, right? So what do you need to know as a business owner about trademarks? All right, so first you want to adopt strong trademarks, right? So you want to make sure that you actually have a trademark before you launch into commerce that's eligible for protection under trademark law, and that also doesn't cause a likelihood of confusion or puts you at a vulnerable place of infringing on an existing mark that's already out there. And you're probably thinking, well, how do I go about doing that? Well, you want to hire an attorney to handle that for you to make sure that essentially that you're not infringing on an existing mark. I can't tell you how many clients I've had that have come to me after year 2 or year 3 and they're like, we're finally making some money, we want to protect our trademark, or they'll say, I got a cease and desist. And I can't tell you how painful it is for them to come to the realization that they have to rebrand. They could potentially lose their goodwill in commerce, which is what trademarks protect, right? You want to make sure that you are protecting the goodwill of your company. And then sometimes when you rebrand, you lose all of the efforts and time that you put into getting that, exposure and that recognition. You lose all of that and you're essentially starting from scratch. So just be very mindful of that and making sure that you do your searches on the front end. A lot of times people will say, I've Googled, this phrase or this name or whatever it is, and I didn't see anyone else that has it. Please don't be one of those people. It is so much more than just a Google search. Since it's a likelihood of confusion, we have spelling variations, sound variations, what does a reasonable consumer think about, or can they essentially think that represents a different company, depending on what it is. Right? So it's a legal analysis that's very, very subjective, and reasonable minds can differ about it in litigation for years. So you just want to be mindful of that. The next thing you want to be able to know is identifying the relevant market, which is essentially like, where are you going to market these products and services in, and to who? There are brands that obviously coexist that have the same exact name, which is why a Google search is dangerous. For example, we have, the Dove soap and the Dove chocolate. They're spelled the same, sound the same, but somehow they can coexist. Reason being is because they are, marketed in 2 different trade channels, and, a reasonable consumer is not going to eat a bar of soap thinking that it's chocolate and, bathe with, with chocolate, right? So that's essentially what the law is trying to protect, that reasonable consumer. As a business owner, please be mindful of your priority use and the priority date of when you use the mark anywhere, and then also when you use the mark in commerce. This is what determines who has the rightful ownership to a trademark. That does cause a likelihood of confusion. So if it's the first in use is the first in right. Even if you go so far as to register your trademark, a company can come and cancel that trademark registration if it is determined that they used it first. So you always want to make sure that you keep track of when you use your marks and what day, the date that you actually used it. So the more specific you can get, the better it is for your argument. And then as you're using your trademarks in commerce, you want to be consistent in how you use them. Sometimes I see people will have 3 different logos that are the same thing, and they're just trying to figure it out, and they want to, utilize one of them, but also the variations of it can be confusing. I mean, not only is that bad from a business perspective because you're going to have a harder time getting that brand recognition with the consumer, it's just not consistent throughout. And so you're going to have to register all of those trademarks. There's like really no one size fit all variations, or one filing fits all variations, right? And then you want to make sure that you're claiming the use of it by designating it. The easiest way to do so is, you use the TM symbol next to each of your trademarks. You want to clearly identify them and make them distinguishable as trademarks of your company. You never want to use the R in a circle until you are actually the owner of a registered trademark and the USPTO sends you a certificate saying that you have a registered trademark, right? And then the next thing, you should focus on as a business owner is, determining the value of your trademark through the goodwill that your company will have, right? So what is the company's value? What are your missions? What does the company stand for? If you're in e-commerce, what are your shipping methods? How fast do you ship? What are your customer service, skills or assets that you have? What makes you different? Why would I go with your brand as opposed to a different brand, right? And those are the things that you want to really focus on as, business owner, because that's essentially what drives the value of your trademark. It's not the fancy logo or the unique name, really, because a lot of the greatest, trademarks that are highly valued, aren't really that fancy. One of them being the Nike check. It's not really a fancy, logo per se. It doesn't require a lot of skill to create it. However, the brand, goodwill that it stands for makes it as valued as it is today, right? And then lastly, just hire an attorney to do the searches for you as well as to file for your trademarks. I always tell people the best time to engage a business attorney is right after you're done with your business plans and right before you start executing them. You'd be surprised at how the law applies at every level, even before you even launch, right? You want to make sure that you're protecting your intellectual property rights from the onset of your business. All right, so now I will open it up to questions. I know that's a lot of information for you guys, but I just want to make sure that I covered as much as I could for a business owner's perspective.
Okay, so if you have a question, go ahead and raise your hand. In the moment, I'm going to run through some of these in the chat box. Hold on. So someone's asking, Salma, can Excel spreadsheets be protected under copyrights?
It depends on what it is. So the answer is it depends, and I would have to do a legal analysis of the content and the substance to be able to tell you whether or not it can be protected.
Okay. And then someone wants to know, what is the typical attorney cost to complete the trademark process?
It varies. So I can't necessarily give you pricing because it all just depends on, who you hire and for how many trademarks that you have. But, they range. And to be honest with you, I really have no idea what the competitors are charging. I have no clue. But it can range from, I would say, maybe bare minimum 2,000 and can go up. So I don't know to what extent, but just depends on what phase you're in. And then also once your application is filed, what type of legal hurdles you might face. So sometimes after you file your trademark application, there are either substantive, oppositions or refusals by the USPTO examiner. Then it could be a company decides to oppose the registration of your mark during the opposition period. So it could really vary widely, right?
All right. Anna wants to know, what if there's a company with the same name, but it's foreign and doesn't do business in the US?
So again, I would say you want to do a legal analysis of that, because if they're advertising their products in the US, then essentially they would probably have priority use, right? So you just want to stay as different as you possibly can. I always tell people this: don't be lazy about your creative greatness, right? So don't just try to bite off of someone else's coattail, and put yourself in their position. Would you be upset if they essentially use something that's similar to yours or the exact same in a different country, right? And what if they have a scandal or their product is essentially explodes and people, you know, when they purchase it, do you want your product to be associated with that? Do you want your services associated with that? So those are the types of things that as a business owner, you want to make sure that you're mindful of, not just from a legal perspective, but you want to think about the business perspective of it as well.
Okay, so G asks, how about if the name has been identified by personalized tags and prior business names before another business in another state started using that same name and spelling?
I'm not sure I understand the question.
I'm not sure either. Hey, G, do you want to expand on that? This is how it was presented. How about if a name has been identified by personalized tags and prior business names before another business in another state started using the same name and spelling?
So if you used it first thing used is first and right. You have common law rights to your trademark, even if you don't have it registered. So if someone else is using it, you want to stop them from using it, presuming that they're infringing on your trademark, and you want to essentially send a cease and desist as soon as possible, because if you don't protect your trademark and other people are able to coexist with you and the consumer does not confuse you, then essentially there could be a defense in the event that you decide to sue them later for infringement, in the sense that they've coexisted for quite some time and there's no confusion. The law is really designed to protect the consumer. It's not designed to protect the business owner. So you as the business owner have to take all the steps to ensure that there's no one else that's coexisting with you. For my firm and my clients that have registered trademarks, we do Trademark Watch, which is essentially looking to see on a monthly basis if there is anyone else that's out there using their trademarks, and ensuring that we're sending cease and desist in the event that someone else is trying to coexist. So the moment you catch it is the moment you want to go after it.
Okay. Can you trademark or patent a nonprofit name?
So I think there's a misunderstanding about patents, but names are eligible for trademark protection.
All right. Should you register for a trademark if you are in real estate, specifically rental properties?
Yeah, absolutely. You know, if you have a business name or a way in which people identify your company in commerce, or even you personally. For example, I've registered the Millennial Business Lawyer as my own trademark. So even if you are selling real estate, you absolutely can file for trademark protection.
Keisha asks, what about if you're starting a body butter business? Keisha, tell us where your body butter business is. I want to know all about that, okay? Is a trademark or patent necessary?
So absolutely, if you're, I presume, is going to have a name, logo, or slogans that come along with it, then trademarks would be implicated. Patents may or may not be implicated depending on whether or not you have a chemical formula that's, you know, new and eligible for patent protection. So if that is the case, you want to seek, you know, counsel from a patent attorney as soon as possible to make that determination before you publish your body butter business, because you have a year to file for patent protection. Otherwise, you lose the right to do so.
I'm serious about this, Keisha. I wanted you to drop your information about your butters, girl. Okay, so, yeah, right? That's something we all need, butters. So someone asked, can we copyright our own PowerPoint productions and programs? And I don't think that person was here at the beginning of this presentation, because Salma and I had to go back and forth. I had to ask her, I was like, okay, Salma, now I see this disclaimer about what can and cannot be used, but this is going up on the DCSBDC website and it is being recorded. Are we okay? So it's a great question, because eventually this PowerPoint is going to live somewhere where people can access it. Now, having said that, you've given the DCSBDC the right to put it up on the website and the right to take this recording to put up the website. But what you haven't given the DCSBDC or anybody on this call the ability to do is
copy or use or sell this presentation in any way. So yes, I did give permission to the DCSBDC, but anyone else would have to seek written permission prior to doing that. So if you do have a PowerPoint presentation that you are selling as a digital product, absolutely you can have copyright protection to it.
And so then the next person asks, will you receive a copy of the presentation? Why, yes, you will, but don't use anything from the presentation. I have a question for you, Salma. So my business is digital media, social media. I'm working with the DCSBDC with you as well and the team members on different ways to help counsel people as they move through COVID and as they pivot their businesses. A lot of folks are using Canva or some of these other free tools because they don't want to hire graphic designers, or quite frankly, it's very easy as a social media person. If something's going fast, you need to be able to create it. You don't have time to necessarily get in touch with your graphic designer because you're in the moment, you've got to go. So they have different images, not just Canva. They do not pay me, by the way. Canva's not giving me a dime. I just use them. So let's get that clear. I'm not being paid, everybody. But that is one example of one of the online tools. They have their free version and they have their paid version. I'm assuming those rights are okay for us to use them if they're giving us a free version and or a paid version. Are we stepping on anybody's copyright infringements by using their images?
So it depends on the terms of use and the licensing that Canva gives you. So you'd have to go and read those, the legal jargon that no one cares about. And each site is different. So it doesn't, just because Canva might give you access or the license to use doesn't mean that all the other platforms will give you that same license. So you literally have to ask and check within each platform that you use to figure out whether or not you have permission to use it. Now, I do know that Canva has the ability for you to create your original, anything that's original from your end, and you want to make sure that whatever it is that you're creating, just understand that if it's not original and you're literally just copying and pasting a template, if Canva gives you the license to use it, understand that they're giving it to other people too, and then now you're going to have the same thing. So if you don't mind that, then you're okay. But you want to think about the business decision in using those templates, right?
Mm-hmm. I think that's great advice. And particularly when it comes to social, people are not reading the terms of agreement. So they join these platforms and then they don't realize how much of their rights they've given away or how much privacy they've given away. And so you see these things that pop up. I do not give X social media the right to use my image and likeness and photos. Well, yeah, you did. You actually did. When you joined, that's what you allowed them to do, is use your image. So I think it's very good advice to tell us, including me. I'm going to go back and read the Canva terms of agreement to make sure that I'm compliant. We all just have to check ourselves as we're doing business and going through this to make sure that we are doing everything legally and properly, and we're setting up our businesses in the right way. Similarly, Gia asked, how does Creative Commons figure into intellectual property?
Creative what?
Creative Commons. So it's another area where you can get video, similar to a Canva, but on a much larger scale, because all they are is about creative images.
Got it. So like where you're able to download certain images that you pay for.
Yeah.
And content. So it's essentially the same. If they give you a license to do so and you're paying for it, then you're allowed to use it, obviously within their terms. So if you do have to credit the photographer, the videographer, the author, then you want to make sure you're doing so. But in addition to that, you want to think about everyone else that's using it and whether or not you want to look the same as everyone else. So again, you either, I know this is like the cheaper option when you're just starting out, it's the easiest thing to do. One tip I can give you guys from a business perspective is I paid a graphic designer to do essentially like templates for me that are original, so that I'm able to just change out the content or the substance so that I'm able to use them throughout and they're consistent, right? So I'm not using the same thing over and over. I mean, a different thing over and over. However, I do have something that's unique and original just to me. And now I know when everyone sees that, they're going to eventually recognize it as my own, right? And then they're going to tie it back to my brand and who I am and what I do. So that's another way that you guys can do it, where you're just paying for one template that you're able to easily edit over and over.
Okay. So Anna asks, what if you're selling a service online and in person instead of a physical product? What aspects should we definitely cover then? And I think you talked about this in the presentation, but
correct. Yeah. So yeah, I would say to kind of watch or replay that first beginning part of the things you need to have in place when you're opening your e-commerce doors, right? And each business is going to be different in terms of what they're going to actually specifically need. So everyone should sit down with a business attorney before they launch, or even if you've launched and you have no idea what you're doing. A lot of the legal mistakes that come across my desk are things that could have been easily avoidable and a lot cheaper than when you wait until something goes wrong.
Okay. And so I don't see any hand raised. Some of these questions you might need to qualify. So if you want me to unmute you, just please let me know. I see your questions. Nikki's is really long. So Nikki, do you want me to unmute you? Let me try to find you. Nikki?
It seems like it's a personal question. So we wouldn't be able to answer that anyway, because it's reflection back to the business specifically. So I would say go through the DCSBDC site to be able to qualify for a consultation, because I don't want to give you just a generic answer that may or may not be applicable to you.
Right. Do you have to trademark the company name, logo, and slogan individually? And when filing on USBTO, do you have to pay for each trademark individually?
So essentially this goes back to the example that I used with Nike. I showed that they had just do it with a Nike check, and I explained how many trademark applications there would be within that one example, and we identified 3. So just depending on how they use it. I know from my personal experience that Nike check is used on its own as its own logo, so a trademark application would need to be filed for that in all of the different registration classes, which is identifying the relevant markets in which you're going to advertise that particular product, right? They also use Just Do It as a slogan on its own. So I do know that that's another trademark application to protect that one. And then when they use them in combination, which is the example that I showed, Just Do It with the Nike check, that's a 3rd application that they would need to register. And then obviously Nike, the name would be registered under a separate, trademark application as well. So it does require a legal analysis identifying how many trademark applications and how many registration classes that you qualify to register under. So I would not try to make that determination by yourself, because a lot of times what I've seen when people do it by themselves, they don't register all their trademark applications, A, and B, they register them in the wrong classes. So, and that doesn't mean that it's going to protect your trademark for where you're using it for. So, and that also requires a legal analysis, because there's 45 different markets or classes under which we register a trademark.
Nayada wants to know, what should you look for in a trademark or patent attorney?
Someone who understands business. That's really important for any kind of business attorney or intellectual property attorney. One of the things that I've seen, throughout my practice is attorneys that don't understand business, it can become very dangerous, because if you solely focus just on the legal aspects of things, it can take you down the wrong direction as a business owner. So you just want to make sure that they understand, the business side of things, and utilize the legal skill to protect your business bottom line, right? So that's the thing you want to look for the most. And someone that understands, depending on what kind of marketing efforts you're using, you want someone that understands social media marketing. You don't want someone that doesn't understand how that works, how that operates, or someone that asks you like, what are hashtags? What are, you know what I mean? Yeah. So those are the types of things you want to look for in today's day.
That can be a little intimidating when you're trying to find the right lawyer. Do you recommend that we, do the Google search and see what they have on their website? Or do we do pre-interviews of our attorneys? Do we get charged for that if we want to do an interview of attorney? It can be intimidating to try to figure out who to partner ourselves with, because our businesses are our babies, right? So it's really hard to try to find somebody or even set ourselves out there to look for the right attorney to represent us.
Oh, trust me, I totally understand that. So I think that first place I would look is your friends and their referrals. Based on their personal experience, because you can trust their experience with any attorneys that they've used, or if they know an attorney that they trust who also knows another attorney. I know for me, personally, I don't have a huge list of attorneys that I refer my clients to, because they're a reflection of me, right? So I want to make sure I vet them, and I want to make sure that I know them personally and how they operate before I just send clients over there. It doesn't matter what area of law that you do. But the ones that I do have, I can do so with my eyes closed and know that my clients are going to be taken care of. you should have a conversation with the attorney that you want to hire if you don't know anything about them. Reason being is because you want to know if it's a good, if it's going to be a good relationship. It's very intimate. You want to feel comfortable about everything about your business. So whatever mistakes you've made, you want to feel comfortable sharing all of those mistakes because you don't want to hold anything back. You want someone that's going to understand that your business is your baby, right? So typically that's going to be like solo practitioners because their business is their baby, right? So, those are the types of things that you want to be mindful of and having that conversation. At my firm, we call them discovery calls whenever we have a potential client that wants to get to know us and the firm. We don't charge for those. We don't call them free consultations because to me that's misleading. If you do want a consultation where we're able to dive into your specific circumstances and now you're asking legal questions, then obviously those are paid consultations, which you guys getting them for free, take advantage of that because they're typically not free. And be mindful of the free consultations because a lot of times it is just a discovery call. It's not free legal advice. So that's why I designate the differences between mine because I think it's misleading to tell people it's free consultation when it's not. So that's something to also be mindful of.
Okay. And so Selma brought up a good point. The consultations with the DCSBDC, particularly under our DCSBDC COVID-19 Initiative, all of us subject matter experts are here to give you the free counseling. So we, take advantage of it, but you have to register on the site. You also have to be a DC business owner or you have to do business in DC. So those are the two prerequisites. If you meet those two prerequisites, go onto the website, dcsbdc.org. I always want to say .gov, but it's not, it's .org, and put in all your information. And you can, be very specific about the help that you need. And you may be guided to a legal attorney. You may be guided to a business development person. You may be guided to myself for marketing. So I just want to put that out there. Those consultations are free, and take advantage of it because, it's really expensive to not do it that way. Right? Yeah. We have about 3 more minutes left, and I'm going to we'll rapid fire a few things. How long do you have to file a copyright before an infringement occurs?
So there's no set time. It's just when someone else infringes on your copyright. I would say remember 3 months. That's the rule of thumb you want to remember. 3 months from date of publication. So don't think about when an infringement occurs because no one knows when that can happen. So just try to do it within that first 3 months so that you can get the attorney's fees and then the statutory damages if you win in court.
Someone says, I have a file photo under a Creative Commons license on his website. There is a copyright firm which alleges that they did not properly attribute the image. And he wants to know how do you qualify those damages?
So it just depends on how much you've made. And determining like the extent of the infringement and what was made is essentially from or profited from that infringement. So it's a case-by-case basis. There is no bright line rule to that. That would require definitely an analysis and figuring out whether or not there's going to be a lot of damages or not. Now, if they filed within the time span that they're supposed to, then there's statutory damages. And then if it's intentional, there's treble damages, which is 3 times that. So it's very, very bad to engage in copyright infringement. So if you find yourself in that kind of sticky situation, seek counsel ASAP.
And then we will end on this last one. What advice do you have for business owners hiring a graphic designer to create a logo? Should they provide some type of legal covering?
So have a contract in place that would make sure that they're going to provide you original, content. And also essentially protect your copyright in the sense of making sure that you are the rightful owner of that particular graphic design. So long story short, hire an attorney to assist you with that process because it's not something that you can download online, which is, I do want to mention this. Please stop with the downloading the contracts online. A lot of times they hurt you more than they help you. There is no free template out there that's going to understand the extent of the transactions that you have to properly protect you. I draft the same transaction in multiple different ways because of the parties that are on both sides. So just be very mindful of that as you're going through and finding free templates online.
All right, so we're going to end there. I'm going to share my screen one more time, but before I go, I just want to share this with you. Ms. Salma is sharp, exclamation point. Great presentation and delivery, exclamation point. So all of these questions are peppered with the thanks from the people who've been on the webinar and giving you great praise. You gave a lot of information in a short amount of time. Just want to, personally thank you for joining us. I know that you're a busy attorney, so it's hard to carve out an hour of your time. So thank you very, very much for this. You've been absolutely amazing. I appreciate you.
My pleasure. Thank you, guys.
Thank you. So coming up next, our next webinar on Monday, the 20th, is Innovation during COVID-19. The topic of discussion is going to be starting and expanding your business. So we've heard about a lot of the legal things that are going to be, that you will need to do to start your business. But now we're going to get into development. What does that mean? So you've got your trademark, you've got your logos, you've legalized everything, and now you're ready to launch. Or because of COVID-19, you've had to pivot and you've had to change your business, or you're ready to expand it and bring in different kinds of contracts. Well, we're going to be talking about that next Monday. As always, you can register at DCSBDC.org, and we hope to see you then. I just want to thank you and thank everyone for joining us. We really appreciate you spending your lunchtime with us. We'll be back again next Monday. Thanks, guys.